Welcome to the Pro Bono Training Institute. In order to complete this course, please view the entirety of this training video and complete and submit the quiz after the video has concluded. The results of the quiz are for your use only and will not be shared. A California Self-Study CLE may be generated upon successful completion of the quiz. You can access this certificate at any point from the My Courses tab located on the top of the website. And now, it gives me great pleasure to introduce you to our trainer.
Hello, everyone. My name is Miguel Soto.
And I am Taylor Valsey.
And we work at the East Bay Community Law Center's Consumer Justice Clinic. Today, we're going to be covering COVID backrent debt and how to help tenants that are being sued in small claims for COVID backrent.
After this learning experience, training participants will be able to assist and advise tenants with 1, the impact of consumer debt versus COVID backrent debt on their credit report and tenant screening report. 2, counseling tenants on their decision to move forward with small claims cases versus settlement. 3, identifying possible improper debt collection practices. And 4, identifying when to consider bankruptcy.
The main things that we'll be covering are the difference between normal consumer debt as opposed to COVID backrent debt on a credit report, as well as a tenant screening report, and how to advise the tenants that's coming to you when they're being pursued. Do they try to defend themselves in small claims? Do they look for an affirmative defense or an affirmative claim against a landlord? Or do they settle their case? We'll also be talking about some of the bad debt collection practices to keep an eye out for, as well as when you can actually use those to your client's advantage, and the times when bankruptcy might or might not be a good idea.
The first topic we're going to cover is the impact of consumer debt versus COVID backrent debt on the credit report and tenant screening report. To understand impact, we must first understand what a credit report is. In California, a credit report is a loose term referring to information by a credit reporting agency about a consumer's credit worthiness, credit standing, or credit capacity. When that information is expected to gauge a consumer's eligibility for credit, employment, or renting housing, it is a credit report. Thus, a tenant screening report is a credit report. On this slide, we have the most common factors included on a credit report, but the one that we want to highlight the most is judgments. Judgments are a significant factor for many landlords because they consider it an indicator of the work that may be needed to enforce their rights. Effective on February 23, 2021, a housing provider, tenant screening company, or other entity that evaluates tenants on behalf of a housing provider shall not use an alleged COVID-19 rental debt as a negative factor for the purpose of evaluating a prospective housing application or as a basis for refusing to rent a dwelling unit to an otherwise qualified prospective tenant. Now, we want to note that debt that is tangential to COVID-related hardship is not off limits to consideration for rental leases or anything else. Thus, other consumer debt acquired in light of COVID hardship is fair game for a landlord to consider and may impact a tenant's decision to move forward with the case.
The next part we're going to cover is how to counsel a tenant that's currently being pursued for COVID backrent. Do they try to defend themselves in small claims, or do they try to settle their case? Because a tenant will likely already be in a position where the rent payments are at least late, the potential for damage mitigation is whether or not the tenant has a judgment against them. In matters where the tenant has a valid defense, like constructive eviction, or whatever housing experts in your unit or that you know of think might be a valid defense, or in cases where the tenant simply can't afford to settle, we encourage the tenant to pursue defenses in the small claims case, and they can even look for and file a counterclaim. If anything, this will help the tenant buy time to build a settlement fund. A counterclaim can also be used as leverage in the backrent matter. If this is the tenant's only debt, for example, you should remember that related to COVID backrent can be considered for housing purposes. So the tenant really doesn't have a whole lot to lose or risk when they're doing themselves in small claims. However, the debt will likely be part of a total consideration over a person's credit score and can be used in determining other things that require a credit screen for eligibility. On the other hand, when a person is vulnerable to housing insecurity, a settlement, if it's affordable, is actually a good option. and should probably be pursued before a judgment is entered in order to help the tenant secure their housing. Even though the COVID back rent debt is not supposed to be considered in housing decisions, you can't unsee something. And there's going to be cases where the tenant may have other debts, or where it may be easy for a future landlord to claim that the decision not to rent to the tenant is based on other debts as opposed to this COVID back rent debt.
Next, we want to talk about how to structure a settlement if you end up having to enter into one. As the slide said, the first thing is to get it in writing. In addition, it's important that you make sure that the written settlement agreement states explicitly not only how much is being paid overall, but when payments are due and how much each of those payments are for. The last thing to specify should be how to make the payments. Quite a few landlords insist on getting a cashier's check or a money order. Conversely, some of our clients have been reluctant to use a check or other means that might reveal to the landlord or the debt collector which bank that the tenant uses. Either way, it's important that those terms be entered into the written settlement agreement. A final thing to highlight here is that a fair number of landlords and landlord attorneys will insist on what's called the stipulated judgment. This is basically an agreement in writing that the tenants will pay certain amounts of money at certain times, and that if the tenant fails to do so, then the landlord or the landlord's attorney can move the court for a default judgment for the full amount. One thing that we've learned is that tenants have the power to negotiate these grace periods if one isn't already included. And so it's important that you do your best to advocate for the client, because in certain circumstances, the client might be a little bit late on their payment once or twice. And if they have the grace period to fall back on, it can make the difference between saving 40% or having to pay the full amount, and on occasion, attorney fees as well.
Next, we're going to focus on bad debt collection practices. Debt collection practices are governed under the federal FDCPA and California Rosenthal Act, as you can see here on this slide. While the state Rosenthal Act incorporates much of the federal FDCPA, there are some notable differences that will impact the applicability of these statutes. Thus, if a landlord, property manager, or property owner is the entity conducting the debt collection for back rent, specifically under the name of the owner of the debt, debt collection laws will not be applicable to their conduct. The rental debt is not a consumer credit transaction under the state law, and the property owner is not a debt collector under the federal law. If the entity collecting the debt is someone other than the property owner, not collecting in the property owner's name, the FDCPA may apply, and the debt collector would need to abide by some rules. Think of a law firm that's trying to collect on the property owner's behalf, for example. Now, the FDCPA has rules around 1, communication with the consumer, 2, communication with third parties, 3, ceasing communication, 4, harassment or abuse, 5, false or misleading representations, 6, unfair practices, and 7, validation of debts. In back rent debt cases where the debt is collector involved, we foresee these acts as the most likely to occur. Now, if you look at the slide, you see some examples of common bad debt collection practices. These can include contacting a person other than the debtor and disclosing information about the debt, contacting a person at their place of employment if they know or should know the person is prohibited from taking such calls at work, or using false or misleading information, such as, if you don't pay, we will levy or garnish. But the thing to emphasize is that the debt collector can't do anything that's misleading, abusive, or generally unfair as part of its efforts to collect a debt. It's flexible by design, so if it smells bad to you, please advise the client to seek help from a consumer protection attorney immediately if the client has experienced any of these acts from a debt collector. Again, somebody collecting in a name other than the owner of the property.
The next thing we're going to talk about very briefly is when it might be a good idea for your client to at least consider bankruptcy. Here's a snapshot of the differences between bankruptcy options for individuals. Because we're not bankruptcy experts, we're only going to talk in broad strokes and from the viewpoint of what factors consumer attorneys look at when they're determining whether a client should seek a bankruptcy consultation. If your client falls under one of the categories that would at least make you want to consider bankruptcy as an option, we highly advise reaching out to a bankruptcy attorney. Most counties' lawyer referral service panels have a list of bankruptcy attorneys most of whom will be happy to do a consultation at low to no cost for most prospective clients. We also want to highlight that bankruptcy is an asset protection tool. Effectively, the purpose of bankruptcy is to protect the client from having to defend all of their assets from individual creditors at various times. That said, it is important to remember from the credit reporting portion that a bankruptcy will appear on their credit report and can be used potentially by future landlords to deny housing. The other thing that we've also found out is that our clients have been denied housing based on a negative consumer report. Effectively, there was no negative tenant report and no criminal history on their credit report. However, past debts were still being reported, and that stopped clients from getting housing. So bankruptcy is not always necessarily a bad thing. If the client's in a lot of debt and is unlikely to get out of it anytime soon, it becomes a strategic decision whether or not bankruptcy will actually be a barrier to getting housing, or if it might actually be an asset to get housed in the future. These are the biggest factors that we suggest looking into when you're deciding whether or not the client should consult with a bankruptcy attorney. Effectively, your client might be judgment proof, which is to say they're earning little to no wages and they don't have any significant assets, in which case the only reason to declare bankruptcy likely be to try to get past debts wiped away so that future landlords might give them consideration when they wouldn't have otherwise. Another thing you want to keep an eye out for are the number and the amount of debts that they have. If the client really only has a handful of debts, or they have one debt that's relatively small, it might be worth considering either settling those or waiting for those to fall off after 7 years from the credit report, or seeing if these individual creditors are going to take any action to try to collect on those debts. A large number of our clients have reported having several small debts that really only result in phone calls or the occasional debt collection letter. But very few debt collectors are going to bother to do too much more to try to collect a debt that's, let's say, $200 or $300. It may be that your client has a lot of small debts, but they're not necessarily debts that will be actively pursued. Conversely, it may be that your client has only debt, but it's a very large one that is very likely to result in a lawsuit. It's an individual decision, of course, but the general rule of thumb that we found is that if there's a lot of large debts or many small debts, that might be worth considering talking to a bankruptcy attorney, whether it's to make sure that you avoid a future lawsuit or simply being able to help the client manage all of these debts a little bit more. In addition to all of that, we found that a fair number of clients who are not currently working or that don't have significant assets often plan on changing their financial situation in the future. So make sure you look to see whether the client is only temporarily disabled or if they're going to re-enter the workforce anytime soon. Bankruptcy can be done at any time. It might not be appropriate to do now, but if your client is in a bad situation in terms of their income at the moment, but hopes to improve it in the future, bankruptcy might be a good option. It can wipe out the debt before a creditor can go after the client and try to enforce any judgments that they get against them. We hope this training has been at least a little bit helpful with you and your clients. If you ever have any questions, feel free to reach out to the Consumer Justice Clinic at the East Bay Community Law Center. And thank you so much for your time.
We hope that you enjoyed this training. Please complete and submit the quiz to generate your CLE certificate. You can start the quiz at the bottom portion of your screen. As a reminder, your quiz score will not affect your CLE eligibility. Thank you for participating in the Pro Bono Training Institute.